Detailed case summary. Case name: Sehaven v. Bremer Handelsgesellschaft mbH, the Hansa Nord, 1976, QB 44 Court of Appeal of England and Wales Judges: Lord Denning M.R., Roskill L.J. and Ormrod L.J. Citation: 1976, QB 44. Background facts. Claimant: Bremer Handelsgesellschaft mbH. Buyers: Defendant: Sehaven v. Sellers. Facts: the buyers entered into a contract with the sellers for the purchase of citrus pulp pellets. The contract stipulated that the goods must be of a fair average quality of the season. The goods were shipped on the vessel Hansa Nord. Upon delivery, the buyers found that a significant portion of the pellets was damaged and not of the quality stipulated in the contract. Consequently, the buyers rejected the entire shipment and sought to recover the price paid and damages. Argument in the court case. Buyers' argument. The buyers argued that the goods delivered did not meet the contractual specification of a fair average quality of the season, and therefore they were entitled to reject the entire shipment and recover damages. Sellers' argument. The sellers argued that the goods, despite some damage, were still commercially usable for the intended purpose. They contended that the buyers had no right to reject the entire shipment as the defect did not constitute a breach of condition but merely a breach of warranty, entitling the buyers only to damages and not rejection. Final outcome and law justification. Outcome: the Court of Appeal held that the buyers were not entitled to reject the entire shipment. Instead, they were only entitled to claim damages for the breach of warranty. The court found that the defect in the goods did not go to the root of the contract, but was a minor defect that did not render the goods unfit for their intended purpose. Law justification. The court's decision was grounded in the distinction between a breach of condition and a breach of warranty. A breach of condition allows the buyer to reject the goods and terminate the contract, whereas a breach of warranty entitles the buyer only to claim damages. The court applied the principles laid out in the Sale of Goods Act 1893, now codified in the Sale of Goods Act 1979. The judges concluded that the term of fair average quality of the season was not a condition but a warranty. The goods, though not perfect, were still commercially usable for their intended purpose, animal feed. Therefore, rejecting the entire shipment was not justified, and the buyers were only entitled to damages corresponding to the diminished value of the goods. Key concept: implications of the Hansa Nord case. The Hansa Nord case is a landmark decision that clarifies the distinction between conditions and warranties in commercial contracts. It emphasizes that not every breach of a contractual term justifies rejection of the goods and termination of the contract. The case underscores the importance of determining whether a breached term is a condition or a warranty, as this impacts the remedies available to the aggrieved party. Key learnings: understand the distinction between conditions, warranties, and innominate terms in contracts. Recognize that the severity and impact of a breach influence the remedies available. Consider the commercial usability of goods when evaluating breach of contract claims. Appreciate the court's role in ensuring fair commercial practices by preventing unwarranted rejection of goods for minor breaches.